Hey, it's John Ray, and I'm here with Kevin.
Kevin Carter, attorney with a Standard Title.
And I'm a real estate agent with Keller Williams here in Lafayette, Louisiana. And there's been, if you've been following along, especially on my social media, there's been a big controversy in regards to short-term rentals and some ordinances that have been proposed. And so one of the questions that has been asked quite frequently, actually, and I think one of the originations of where some of these ordinances have come from is what are the neighbors' ability to state the rules, quote unquote, in their neighborhood? So Kevin's going to answer some of those questions today.
So generally when you establish a neighborhood, you'll nowadays appoint an HOA, a board, to kind of be the police of the neighborhood, enforcement of restrictions and guidelines that must be abided by people purchasing the lots. And at the same time, they'll also draft all of those guidelines that must be abided by.
Like, I can't paint my house purple, I got to keep up my flower
How
beds.
high your fence has to be,
Yeah.
setbacks from the back, from the front, from the side of where your structures can be, what kind of structures you can have. So those are all called your building, your restrictions and covenants that people who are purchasing must abide by.
Sure.
And anybody who buys, and that's generally going to be set up, both the HOA and the board and the covenants and restrictions by the developer. And any new purchasers coming in are going to be bound by those, because all of those things, those are, in general, all of those documents are called the community documents.
Okay.
The community being the neighborhood itself. And those will all be recorded in the public records. Louisiana has what's called the public records doctrine, meaning when you buy something, when you buy a parcel of land, a lot, you are responsible for knowing and you're going to be restricted by those covenants and restrictions that of anything that's recorded.
Sure.
Whether you're an attorney or not, whether you can read legal work or not, whatever's recorded in the public records, you must abide by when you purchase. Whatever's recorded at that time you purchase.
So it's a really good idea that when you're purchasing land, a house, whatever, that you ask your real estate professional to make sure that the title company or somebody gets you a copy of those restrictions and those
Right.
HOA documents and whatnot, and that you actually read those.
Right, because as a title company, we're going to verify that you're going to own the property 100%, make sure there's no liens or encumbrances or mortgages on the property. But we don't know exactly what you're going to end up doing with the property.
Sure.
So if you have a client that's an investor and they want to do a short-term rental, or they just want to do a regular lease, make sure that you verify, because we've had several instances where people are buying what they want to be a short-term rental, and then their HOA is like, no, you can't do that. Here's our restrictive covenants, and you just can't do that. Now, we as the title company don't necessarily know that that's what you're going to do, so it's not for us to be able to find out what you want to do up front and tell you can't. You
need to talk to your real estate professional, and if they can't find them, then the title company can get you a copy of them.
Yes, certainly if it's going to be a business, it's not just your residence, absolutely request those from your title company and have them reviewed by your favorite title attorney.
I would do it even if it's your residence. That way you know you don't get the fine for leaving your trash can out for too many days.
It's certainly good to look at them through and through before you buy as well.
So if I am living in a neighborhood right now that has an HOA, let's go there first, and I have an issue with a badly managed short-term rental that's in my neighborhood, what are my options?
Now, what do you mean badly managed?
So they're throwing parties all the time, noise ordinances, like too many cars are all over the place. Like, do I have any options about that?
Yes, so you would tell your board, if there's an HOA, you'd tell your board, hey, this is going on. I believe that they are breaking some of the restrictive covenants from the neighborhood, and we would like you to enforce them. They'll check it out. They'll give them a warning, let them know. The board will let them know, or the board will get their attorney. Typically, HOAs have an attorney already contracted that's going to represent them to send them a demand letter to remove the obstruction or stop the partying. And then if they continue to do it, then you can start putting liens on the property and issuing injunctions, having a court orders to stop. So then you start getting into legal fees that you can impose on them. And so that's what pretty much the role of the HOA is to enforce and all of the restrictive covenants. And yeah, pretty much that's what you would do. You'd go to your board and have them take care of it.
Sure. So what if, let me take you out of a neighborhood with an HOA, because we have lots of old neighborhoods in Lafayette that never had HOAs.
Right.
And so let's say I have the exact same situation. We're not getting into the fact that I just don't like short-term rentals right now.
Sure.
This is a badly managed short-term rental. What are my options there? Do I have any?
Yes. So you would as the neighborhood, you have the ability to any lot owner, any single lot owner in a neighborhood can enforce covenants and restrictions. So they would personally get their own attorney to go get the title work done, or have the restrictions and covenants and restrictions pulled, reviewed, find out exactly what's wrong or what's being violated. Then they could have their own attorney send a demand letter to the property owner and demand them to stop doing whatever it is they're doing. And then after that, same thing, except it's the property owner doing it now, spending their money to have an attorney go to court, have a judge tell them to stop.
Okay.
Whereas if it's an HOA, they're going to spend the HOA's money.
Sure.
And your dues and fees that are going into the HOA are going to pay for that attorney.
Which is still the property owner's money. Right?
Yes,
You know?
but it's all the property owner's money.
Yeah, it's all pulled together.
Yes, exactly. So that's kind of the difference. That's an HOA is a body that takes care of its residents, whereas and enforces the covenants and restrictions. If you don't have the HOA, then you have the property owners themselves having to fork over the money and do the work themselves.
Okay.
But enforcement, by either manner, they're going to look at whatever documents are filed on behalf of the HOA, the community, or of the subdivision. Whatever documents those are, all of them will look at them to see if there's any restrictions in them and enforce those.
So what if there are no restrictions? What if there's nothing that would prevent a short-term rental from being in my neighborhood, and a group of the neighbors really are uncomfortable having a short-term rental in our neighborhood?
Sure.
Do we have any options there?
Yeah, so if you don't have even if you have restrictions in place, but you look at the restrictions, there is no restriction that says short-term rentals can't be in here. A lot of the older ones will say no commercial uses. But let's say, for example, let's just start there. There's nothing that says, under any interpretation, that a short-term rental can't be in there. Anybody in the neighborhood can then go to the covenants and restrictions and say, how do I get an amendment done that says no short-term rentals? So a body of, it's going to say in your documents what percentage, is usually more than 50% of the land area owners. Okay. It's not actually the number of people.
Okay.
It's actually the land area or the number of lots. The majority of the number of lots that are owned would like to add a restriction. And if they get the signatures, then you just file it in the public records, and that's it. Then the amendment is done. And now no more short-term rentals. However, the case law is pretty clear that it will not be a new restriction. So if you have an Airbnb being operated, a new restriction saying no Airbnbs or no short-term rentals will not be retroactive. So that one, if they were doing it before, they'll be able to continue to do it.
Okay.
So the retroactivity, right, and that's pretty much across the board.
But that goes back to what we were just talking about.
Yeah.
Like when you purchase a property,
exactly.
Usually you have an agreed upon, buyer seller agrees that there's a due diligence, a time to do inspections and all of your due diligence, where hopefully if you're planning on deploying this piece of property as a short-term rental or putting it in use as a short-term rental, that you've done your research and you know that there's no restrictions against that.
Exactly.
And so that would take away some of my rights if I had done my due diligence.
Yeah, and I think that's fair. I mean, you're buying property and you are charged with the knowledge of the covenants and restrictions. Okay, you bought it, you reviewed them, you did your research, you did your homework. Airbnbs are allowed, but and so you do one, and you've purchased the property, you've got a commercial loan for that purpose, and then a restriction comes in and said you can't do that. Well, my opinion or not, the courts have said, and I'll just read you one case, the underlying issue in this case is whether a restriction not applicable when a lot is purchased can be later imposed on the property. Building restrictions are to be construed strictly and have no retroactive effect. So that's a case where there was no HOA.
Okay.
And then in the HOA, there's a Homeowners Association Act in Louisiana. It's under 9:1141. It says, in the absence of building restrictions in the community documents, no new or more onerous building restrictions shall impose a duty on the current owner to affirmatively act.
Okay.
So basically, the HOA can't come in and make them if they've already started doing it.
Okay. No, that makes complete sense.
Yeah.
So, and I bet you the opposite is also true, that if the restriction exists and the HOA decides, no, we can remove it, then if I'm a current property owner, I could then put it in service as a
Oh yeah, sure. If there's no restriction against it and the zoning allows it,
Yep.
Then it's okay. Now, I just want to mention where we were on the commercial, a lot of the old covenants and restrictions, and even the current ones say, no commercial activities. So then there's this big argument in the country, really, of whether
it's not just here.
Whether a short-term rental is commercial or residential. So if it was designated as commercial, then it wouldn't be allowed.
Okay.
If it was designated as residential, then it would be allowed because it's a residential purpose, not a commercial purpose.
Okay.
So our neighbors to the west, I think that's west, yeah, Texas.
Yep.
Their Supreme Court has said that short-term rentals are residential. They've ruled on it. Louisiana courts the Supreme Court has not ruled on it yet. The circuit courts have said that no, it's commercial.
Okay.
So the Louisiana lower courts, there's really not a lot of case law in the entire country on this.
Yeah. Well,
it's coming.
They're relatively new.
They're relatively new.
10
So
years-ish is not a long time.
And it takes a while to get to the Supreme Court after a lot of litigation, and then you have a lot of cases that just fall off and don't make it there. So no case that I could find has made it to the Supreme Court to determine whether it's residential or commercial. But some of the lower courts have said that in Louisiana, they're commercial activities, likened to a motel or a hotel.
Okay.
So that's who they're competing with.
Okay.
Yeah. So that's kind of how.
And that is the argument against them right now.
Yeah, and that's just kind of the track some of the circuit courts have taken.
Yeah.
In my opinion, or not. It's just how they're interpreting. Some of the judges are interpreting it. Yeah.
Interestingly enough, some of our agents in our board have actually started sitting down with some of these concerned citizens who have some of these poorly run Airbnbs or VRBOs or short-term rentals. And a lot of the platforms actually have a way. I'm not familiar with it. I don't manage actively short-term rentals. But a lot of the platforms have a way for the neighbors to voice a concern about a poorly run short-term rental. So if you're next to a poorly run short-term rental, that may be an option for you.
Yeah. Interesting. I didn't know that.
Yeah, I did. I found it out last week. So.
News to me, but it's good to know.
So, anything you want to add?
No, just obviously it's a hot topic. I will say that whether I think the argument right now or what's being argued right now downtown is the new zoning, whether they allow them or not. Mm-hmm. Correct me if I'm wrong. I'm stuck in an office doing title a lot, so
sure.
I try to keep up as best I can.
Yeah, there's two ordinances out on the table. One of them would completely ban
let's
them.
talk about that. Go ahead and mention that.
Yeah, so one of the ordinances would completely ban short-term rentals in residential RS1 zones, right? And both of them, the other one would allow them, both of them would impose some pretty hefty regulations on them.
Sure. So basically you're given two options here by the council, and that's what they're arguing about. Let's just, forget the imposition of the hard measures if it's allowed. It's either allowed or it's not. If it's not allowed, it's done.
Yeah.
Right. If it's allowed, then you go to your covenants and restrictions. So let's say it's allowed. Well, then the neighbors can get together, and the HOA, if there's one. If there's not, then the neighbors can get together and do an amendment to the restrictions and add one to not allow it. So that's the process they would go through. Now, if downtown puts the zoning in that allows it, and there's already ones there, and then the neighbors get together and go and put an amendment that doesn't allow it. Well, the ones that have already been established, I'd imagine are going to be allowed.
Yeah.
So that's kind of all the little tracks that are going to be taken.
Yeah.
Once they decide on all these things.
So you have a voice. Get involved. Speak up. It's how our government works.
And I'll tell you, it's a hot topic for sure. And it's just it's.
When I can honestly see both sides of the situation, you know, and I think hopefully we find a middle ground where, you know, there's compromising on both sides.
It's always nice to compromise.
Yep.
You know,
So,
make everybody happy. I doubt that's going to be the case.
We'll see what happens. But look, I mean, so now you know that you have the ability, whether you have an HOA or not, you have the ability in your local neighborhoods to begin a conversation with your neighbors, and if there's enough involved, you can actually change the restrictions and guidelines for your neighborhood.
Yeah.
So
Pretty short and sweet. Yeah.
sweet. Thank you, Kevin.
All right. Every day, anytime, man. Good to see you again.
You too.